Ladies and gentlemen, we're now going to start the session 5, and this session is a debate. This will be moderated by Mr. Nish Shetty, MCIA Council Member, Head of Litigation and Dispute Resolution, Clifford, Southeast Asia. And there will be 2 groups of debaters. As debaters for the motion, Lord Peter Goldsmith, Queen's Counsel, Co-Managing Partner, Debevoise and Plimpton, former Attorney General of the United Kingdom, and Mr. Gopal Subramamaniam, Senior Advocate, former Solicitor General of India. And on the other side, as debaters against the motion, Mr. Toby, Landau, Queen's Counsel from Essex Court Chambers, and Mr. Neeraj, Kishan, Kaul, Senior Advocate. And the topic will be introduced by Mr. Vyapak Desai, partner of Nishith Desai Associates. Over to you, Vyapak.
Thank you. I think this is the most hotly debated topic when it comes to India, because I don't think we have any precedent elsewhere in the world where a provision like Section 29 is introduced in a statute. Before this was introduced in 2015, everyone said, oh, in India nothing gets done for decades together. And then possibly it was termed as a serious disease in terms of delays. And when, as we know, serious diseases required critical surgeries, 29A came handy to say, okay, everything will be done in 12 months unless parties extend for another 6 months, and therefore maximum time period is 18 months. And suddenly this became a widely debated topic. And then came the new proposed amendments of 2018, where they tried to dilute this provision by saying that these provisions will not apply to international commercial arbitrations. So basically now international commercial arbitrations may not have timeline as we go along. And as far as domestic arbitrations are concerned, they said that there would be an additional period of 6 months for completion of pleadings before the 12-month timeline triggers, which means it is instead of 12 plus 6, it is 6 plus 12 plus 6. Though the 6 months of pleadings are defined to be only statement of defense and statement of claim. So I think there are 2 or 3 issues which come up, and we thought this may be the right time to have a pre-Diwali fire-cracking debate before we end our session. Though we will make sure that it doesn't go the lines the way we see debates these days on television. So we have moderator Nish to control that. But definitely, if not nation, MCIA definitely wants to know as to what is this pendulum and which way it is going. So just to put it in a perspective, and then I'll hand it over to Nish. There are 2 things. People said, okay, too much of delay. So we said, okay, unless we bring in timelines, nothing happens in India. And we need that stick to really work. Otherwise, as we always say, we believe in reincarnation. So we never finish everything in our lifetime. But when the issues of new 29A in 2018 came about, they sliced the cake between domestic and international commercial arbitration, while the report was all about institutionalization of arbitration. So one suggestion is whether we need to slice the cake between ad hoc and institutional rather than domestic and international, which means you may want to give institutions the credence to manage the timeline, but when it is domestic, you stick to the timelines the way it is prescribed. That will also incentivize people to go for institutional, whether it is domestic or international. So there are various ways to reach Makkah, as we say, as far as the timelines are concerned. But I think hopefully we'll have some direction at the end of the debate And before Rajya Sabha looks at these amendments, maybe we can produce a white paper post this debate as to this is what we have concluded, and that's what we are looking for. Thank you.
Thanks, Vyapak, for that very clear introduction. Ladies and gentlemen, good evening. It's 5 p.m. on a Saturday, and we have a full house. So apologies to the PCA for that. But it's wonderful to see all of you here. I think we're going to have a really lively debate. I just want to talk about my own journey in relation to this particular provision in the Act. I can tell you that when it was first passed, I was one of the vocal opponents to it. I thought it was a bad idea. I thought it was impossible to finish an arbitration within 12 months or 18 months. And what would end up happening is you would end up with the same matter in court for the next 15 years. And that was my thinking back then. As things progressed, I was told by my colleagues and friends on the ground in India that it's actually not worked out quite that way. The starkness of the provision itself has jolted the Indian system such that people have accepted the reality that it needs to be done within a particular time frame. And it has had a whole lot of other unintended consequences as well, and no disrespect to any Supreme Court judges in the room, or ex-Supreme Court judges in the room, that certain judges were no longer taking appointments because they felt that it would be beneath them to ask for extensions before a lower court. Again, I'll leave the debate as to whether that's a good thing or a bad thing to another day, but certainly it did have consequences on the ground in India. And by and large, I'm told those consequences were positive. Now, unusually... We can take a vote now. We'll wait for that, Toby.
The Supreme Court justices are complaining about their
Yeah, that's all right. They're ex anyway. Unusually, very shortly after that, in 2018, we're now looking at further amendments that might well dial back some of those changes. And I, for one, am looking forward to the discussion and the debate that's going to take, actually it's not a discussion, sorry, it's a no-holds-barred debate that's going to take place shortly between the two teams here on this interesting topic of whether the pendulum has swung too far the other way by virtue of the latest amendments that have been proposed. As was described just now, for the motion, we are going to have Peter Goldsmith and Gopal Subramaniam, and against the motion, we're going to have Toby Landau and Neeraj Kishan Kaul. The format's going to be this. We're going to have one speaker from each team start off, speak for 8 minutes, followed by the first speaker for the other team, and then it's going to pass back to the first team and then the second, and there'll be short rebuttals thereafter. So without further ado, can I invite the first speaker for the motion to start the presentation? I think it's on.
The British Psychoanalytic Association is a journal, and it has recently said that chiding children unnecessarily in the primary classes produces adverse psychological effect. I never thought that the legislature, in a section called Section 29A, would chide arbitrators, but the effect appears to be far removed and far more ironic than what was intended by the Journal of the British Psychoanalysts. 29A is a provision which, to put it very mildly, is simply inconsistent with the entire ethos of the 1996 Act. It is a flagrant violation of the model law. It is in the teeth of Section 2, subsection 8. It is destructive of party autonomy, but more than anything else, I think, arbitrators have some sort of autonomy and freedom to conduct their proceedings with a degree of ability, competence, and integrity. I do think that Section 29A is destructive of anything which is civilized in international commercial arbitration or in any reasonable domestic arbitration. Let's start with looking at 29A. And it's indeed ironic that it's a capital A after section 29. Subsection 2 gives an incentive, and indeed it's an unknown incentive, that if you are an arbitrator and you complete the arbitration within 6 months, you could get additional fee. I think it's something unheard of. And I think any legislature which prescribes this clearly, with great respect, as I said, needs very severe reflection. And I don't see any reports which have actually suggested that payment of more fees within 6 months would lead to better results. Then we come to something even more anachronistic in section 29A. What happens after 18 months? After 18 months, the legislature very pontifically declares the mandate of the arbitrators having been terminated. And then it says it shall be extended before or after the time has expired when the court has intervened. But where does the court come into the arbitral process? We thought that this whole 1996 Act was intended for the courts to be shooed away until actually it was necessary for them to examine an award after the award was pronounced or unless it came to a matter of appointment of an arbitrator. Well, then we come to the need for making an application. What does the court do? The provision says it must be for sufficient cause. I haven't understood what would be the sufficient cause which any party would show. Obviously, when you have an arbitration, one party wants to prolong it a bit. One party doesn't want really to carry on with the job. One party wants to resist discovery. One party's lawyer seems to be regularly having bronchitis. Having said all this, now, what is the sufficient cause? Then the court can impose terms and conditions. I haven't understood what are those terms and conditions. Then I come to another subsection, which is even more hilarious. The court shall substitute one or all, any of the arbitrators. And I think it's absolutely fascinating to see party autonomy to be completely overtaken by court. Are arbitrators school children? Are they going to be chided in this way? And then thereafter, what do we come to? There can be imposition of exemplary costs, if necessary, by the court. I think this provision is a complete, if I may say so, redundancy. And it's time that somebody actually wrote a short, brief, crisp piece that you don't need a provision like this to regulate arbitrators. The fact that arbitrations are often prolonged, if I may say so, is not due to the fault of anyone except those who lack incompetence or those who are meant to conduct arbitrations as responsible counsel. But it certainly does not call for what I think is a completely misplaced legislative panacea. It is indeed distressing to see that the legislature embarked on this. But let's come to the bill. The bill is even more curious, or the suggestions are more curious. I've never heard that arbitrators must ever be heard before their fees are reduced. I mean, the arbitrators now become parties in their own cause. What exactly is all this about? This is a far movement away from the UNCID trial. It's a far movement away from model law. Model law is incorporated, well, not like the Singapore Act, where it's a part of the Singapore Arbitration Act, but we do embody and respect the model law. We have based whole judgments of the Supreme Court of 5 learned judges on the prepatwa of the model law, and I'm very sorry to say 29A actually, there's not a pendulum. The pendulum has got stuck the other way. Thank you.
We're off to a good start. Debaters against the motion. First speaker, please.
The importance and necessity of this amendment has to be seen in the background of why was it needed. two or three important factors to be kept in mind. One is your national judicial data grid says 3.3 crore cases pending, 10.5 judges per 1 million. Given these statistics and given the circumstances that we are dealing with, we are looking at decades for cases to be decided. Now, ordinarily in a situation like this, arbitration is possibly peculiarly important to the Indian context, and we should have had a robust and efficient regime in place. But we've struggled to have a robust and efficient regime in place, and many reasons are responsible for it. We have a large majority of ad hoc arbitrations in this country. One reason being that we don't have a dedicated bar or a pool of arbitrators for institutional arbitration. Secondly, a dedicated bar of lawyers who only concentrate on arbitrations in this country, leading to a situation where far more often you have all arbitrations after court hours. There are 3 arbitrators, lawyers exchanging dates, which take 3 months for dates to be given for the next hearing, resulting in undue delays which take place. And the self-regulation which the 246th Commission talked about, the Law Commission talked about, I haven't seen that coming in the last 23 years. The 176th Law Commission report emphasized on each of these needs and said it's time that we have a statutory timeline. The 246th Law Commission said that possibly the cultural revolution should come from within. It hasn't come from within. So when we say that courts were meant to be kept away, of course courts were meant to be kept away. But if that self-regulation and self-discipline, which was required of the arbitrators and the lawyers in this country, has not come, I think the time and need has come for some form of a statutory time frame to be introduced. The World Bank in its report on doing business with India, and as far as perceptions are concerned, rates us at 131 out of 189 countries. A recent report of the Niti Aayog says that it takes as long as almost 1,420 days to complete an arbitration, and 39.6% of the claim value for dispute resolution in this country. Now that's the background that we are dealing with. Ordinarily a step like this was not needed, but urgent circumstances, urgent needs required remedial measures of the kind which has been brought about by the legislature in its wisdom in the present case. Now coming to the specific provisions on party autonomy, for instance. Now I don't see how party autonomy in any way is affected in this matter. Let's look at a few instances. Parties can choose, have their own institutional or ad hoc arbitration. They can have a single or 3-member arbitral tribunal. They can choose the language. They can choose what procedure is to be followed. They can choose whether it's a document only or an arbitration or not, whether oral evidence is to be permitted, what is the procedure for challenging the arbitrator should be, whether it's an award which requires reasons or not, except for timelines, which is the one thing which the legislature in its wisdom has today put a curtailment on. And there too, the parties can go, either of the parties can go, and this request can be made to the courts at any time. It needn't be made after the 12-month period is over. In any given arbitration, the two parties can decide and go well in advance. It could very well happen that in a complex case, while the case management takes place at the initial stage, the arbitrators may tell the lawyers that this is a case which would require more time. Please go in advance and get the time that you're required to get in this matter. So this whole bogey of party autonomy going, and the whole criticism is illusionary. According to me, there's a lot of speculation in this. We must let the amendment work out. We must wait to see what happens. And in case there is a problem, surely the courts and the legislature will step in to improve wherever the improvements are required in a matter like this. So to say today that party autonomy has been done away, I do not agree at all. According to me, even to say that an arbitrator can be changed is not demeaning. These are not orders which are passed in the ordinary. These are orders which may be passed in the rarest of rare cases in exceptional circumstances. Secondly, the arbitration proceeds from the stage where the arbitrator is changed. Exceptional costs is, I think, badly needed in this country in arbitrations, because the way at times lawyers and our arbitrators conduct these arbitrations leave much to be desired. And it is a fact which each one of us has experienced when we've gone in for arbitration, that these are convenient dates which are exchanged, and half the time it doesn't suit the 3-member arbitral tribunal, half the time it doesn't suit the lawyers, because everyone is looking at post-court hours to decide and have their arbitrations, preferably on weekends, leading to huge amount of delays in a matter like this. So according to me, let's wait, let these amendments work out, and then criticize them. It's a welcome measure, a badly needed measure for India today.
Excellent. I'm persuaded.
Thank you for that. Peter Goldsmith.
So I don't imagine that anyone in this room disagrees that there are problems with the Indian court system, which is where my opponents started. But it's a far cry from recognizing that than to saying, and the answer to that is to impose an unfair, unworkable, uncertain system, not on the court system, but on arbitration which parties have chosen. And I do, if I may say so, find the final remark, which is, well, let's just see how the amendments work out, a peculiar way of saying that the system which has been produced is one that is working, is one that is good. Now, the title of this motion is, has the pendulum swung too far? Actually, in the version I've got, it is, has the pendulum sung too far, which at first I thought it required us to have some singing award as opposed to speaking award. But understanding the motion properly, we have to ask, and you will have to ask yourselves if you're called upon to vote, which I imagine you will be, do you think that what has been produced is actually working? And to be told the best answer to that is to say, well, it probably isn't working, but let's wait and see if some other amendments might achieve it. Let's just examine some of the points that have been raised so far. Party autonomy. Well, you've heard that a court can be in a position to remove an arbitrator, or all the arbitrators. Doesn't, incidentally, the Act doesn't say, and then invite the parties to appoint substitute arbitrators. It says the court does that. Well, that seems to me a very huge intrusion into party autonomy. It says that the court will have to inquire, if it's asked to extend the time, if there are appropriate circumstances. It gives no guidance as to what those circumstances are. Presumably they're not just, well, we haven't finished, because if you haven't finished, that's not going to be a good enough answer. So how's the court going to do that? Well, it'll have to examine the party's conduct and the arbitrator's conduct. It will have to go into privileged matters. It will have to understand why something hasn't taken place. A better way of turning a private arbitration into a public scandal, I cannot imagine. And then the proposal to incentivize or disincentivize arbitrators by changing their fees. Now, the experience I've got of the courts in my country is as soon as you talk to sitting judges about arbitrators' fees, they have a number of emotions. One of them is envy. One of them is looking forward to their own time as arbitrators. I recall one senior judge making some trenchant criticism of fees that were being paid, and it was described as post-practice remorse. These are not sound bases on which to make judgments. They're not sound bases to make judgments at all. So you'll have a situation in which a court will have to examine what has happened in the arbitration, form a view about the conduct of the parties and of the arbitrators, decide if somebody should be removed as an arbitrator and replaced somehow, and then potentially change the fees. Now, I think all of us know that being properly remunerated, of course, is a good thing. But just incentivizing somebody to rush towards a bad judgment for fear that otherwise they will lose their fee, or worse still, that they will get an increased fee, seems to me inadequate and inappropriate. At the end of the day, the arbitral process, like the court process, has to produce justice. Yes, there's a balance between time and justice, but you don't get that balance right by incentivizing somebody just to say, you've had your chance to produce evidence, I'm producing the judgment today, that way I'll double my fee. So I would invite you, when you come to vote on this motion, to say, maybe somebody can improve the situation. Maybe it is time to allow institutional arbitration, which is what this conference is about, to produce a system in which institutions can manage, can incentivize arbitrators, can choose arbitrators who do the job properly, can help to nudge them in the right direction. But let's not have this unworkable, unfair, uncertain system to do it.
Toby.
Ladies and gentlemen, enough is enough. For years now, we have been trumpeting how arbitration is fast, efficient, flexible, and cheap. And yet, in parallel with this, for years, we have been attending international conferences where we bemoan delay and cost and inflexibility in the process. This is an ongoing deceit. We can't still pretend that arbitration is faster and more efficient than court. In fact, it seems to be common ground that we have a problem. There's no dispute between the sides on this, that delays have become an endemic, inherent, embarrassing issue for international arbitration. We are all searching for answers. We have thought about creating fast-track arbitration. But please bear in mind, fast-track was only ever invented after the invention of slow-track. The comparison with courts is now shameful. And this is a competitive market. We have got to break this cycle. There are 3 points I'm going to make to you. Firstly, let's understand the true causes from an international perspective of the delay that we are always talking about. We've been talking about for years. And secondly, let's look at what has happened so far to try and cure that. And lastly, how does this Section 29A fit in with that? Now, if you look at the first one, what is actually causing this delay? There are stages in the process which give rise to delay. The blame is shared between arbitrators and parties and arbitral institutions, I'm afraid. So institutions are not the answer, not the complete answer. You have time, first of all, to constitute the tribunal. Very often it's institutions that are taking a huge amount of time to actually constitute a tribunal. You've got time to convene the process once the tribunal is constituted. That is a function of overly burdened tribunal diaries, where tribunals simply take on too many cases, because that's the modern business model. You take on as many cases as possible, and you have an army of assistants to help you, and they're unavailable for first sessions. Often they're unavailable because they're attending international conferences about delays in international arbitration. And then you have got standard form procedural order number 1, which is, of course, the automatic procedural order number 1 that creates, if I can put it this way, too much procedure. Too many steps, which are not always needed, actually, for arbitrations. We say, well, arbitration can't be resolved between 12 and 18 months, but actually, it frequently, easily can. The reason it can't is because there's too much process, too many memorials, too unstructured, too much time on document disclosure where documents will never be looked at, too much scope for big law firms, none of which are represented in this conference, to churn, to go into autopilot themselves and throw lots of unnamed associates at the case in windowless rooms, drafting for hours and days and weeks on end. And on top of all this, we have tribunal due process paranoia. Due process paranoia means tribunals do not feel able to stop this redundancy because everybody has a right to a fair hearing. And that means there will be delay. Then you have the curse of the post-hearing brief, and then you've got deliberations. And deliberations is where the maximum amount of delay is injected into this process, I'm afraid. Again, nobody in this room, let me make that clear, before I effectively end my career. The problem with deliberations is that because there'll be a post-hearing brief, tribunals aren't really listening towards the end of the case because they're going to read it all later anyway. So somebody may be summing up, but your arbitrators are looking at the clock in order to work out how long it will take to get to the airport to get the flight to their next hearing or the next conference to deliver their paper on we know what. The problem is then meeting afterwards, and tribunals take a long time to actually get themselves together and meet, and then they take a long time to draft, which is understandable because by that time the whole case has gone cold. A commercial judge will have gone out of the last hearing, gone back to his room, his chambers, and started drafting. If you leave it for 5 months, how are you ever going to then speed up and create something good in a good space of time? So, and the last thing I'll say is that we also have a phenomena in arbitration now, which is known in other fields. It's called social loafing. If you are a co-arbitrator, you will suffer from social loafing. That means in a group setting, you'll let the presiding arbitrator do the work until you have to actually concentrate and focus. Now, we have been through this forever. We know that there have been many attempts to actually stop this delay. I didn't hear from the other side any concrete proposals. Did you? We've tried self-regulation. It doesn't work because arbitrators are not minded to change their business model of flying from arbitral tribunal to conference to arbitral tribunal. You won't get regulation from them. Can you rely on the market? Well, just stop appointing overly busy arbitrators. You can, except parties want members of the mafia. And so it's difficult to actually say we're simply going to take a risk on some new person. Can you trust the institutions? Well, the institutions are trying, but they haven't succeeded. They ask arbitrators before cases begin, what's your availability like? And there will be a standard response from the extremely busy, unavailable arbitrator, and it'll be, it's good. My availability is good. Cases may settle. We don't know about the future. Diaries are fluid. And then we have institutional rules which actually impose deadlines for tribunal awards. Does that work? No. The ICC has always had a 6-month rule which routinely is extended because nobody really wants to upset members of the mafia. And then you've got ICSID. ICSID says you've got to render your award in a certain amount of time from when you close the proceedings. Brilliant. You don't close the proceedings. That's what happens in ICSID. You close the proceedings several years later when you're ready to render the award. So ultimately, we've got to the stage, I'm afraid, where we need something new. We have got to have a jolt. We've got to stop attending these conferences, apart from this one. And so the beauty of Section 29A is, it may appear to be blunt, but its beauty is it actually addresses the real causes for the first time. This is where India has led the world. For the first time, arbitrators can't protect their own position by simply saying, I need more time. Parties can't stitch up the process. Counsel can't stitch up the process by agreeing to a lengthy procedure amongst themselves. It's an answer, amazingly, to due process paranoia. For the first time, you've got a law telling you you've got to speed up. That means a tribunal, for the first time, can actually say, as a matter of law, I'm not letting you put in a second memorial because we'll go over the time limit. That is a fantastic answer to due process paranoia. Actually, as a matter of law, the parties have contracted into something which doesn't allow them those kinds of objections. That has got to be preserved, and that's got to be learnt from in other countries around the world. And this is also a way of disciplining institutions. It's not to displace institutions, it's to give institutions teeth. We don't have to hide behind diplomacy anymore. We don't need to worry about upsetting members of the mafia. It's not us saying, can you please get a move on, because nobody will dare say that. It's the law. It's neutral. It's objective. And it sits above the whole process. Ladies and gentlemen, the Sufis have a doctrine which is called Hark al-Ada, and it means breaking of habit or custom. Literally, ripping custom or habit asunder. In one of its meanings, it refers to miracles, whereby God suspends the habit of natural phenomena. But in another of its meanings, it is actually a rigorous spiritual practice, whereby one is made actively aware of the forming of habits, and you force yourself to break the habit. We haven't managed to do that yet. Now we know it's manifest. We need that external jolt to break our collective habit. And if we do that, which Section 29A will do, don't get misled by Lord Goldsmith's very eloquent, superficially attractive arguments about uncertainty. Because so we know so far there haven't been problems. The only people who don't like it are the arbitrators, and that's telling. There haven't been those manifest problems so far. So we need that external jolt. We need to get out of this habit of delay. we need to look afresh at our process. And who knows, we may then have the miracle of no more international conferences on delay. Please, I urge you, oppose the motion. Thank you.
Of course we're ready for rebuttal. Why do we need any time to consider the answer to that argument? I mean, the thing about Toby, all of you know this, he's a wonderful advocate. You can't see the joins. But be very careful. You heard a speech which was about the terrors of the mafia. Who made it? One of the capo di capos. Well, maybe he knows how they do it, but this is a man who knows all of this. But what has he actually told you? He told you that this is a beautiful section. Well, really, can you look at this section with the uncertainties that it's got, with the absence of clarity, with no indication of how you're supposed to decide what are appropriate circumstances for it to go longer? How do you reduce the amount? Who do you choose as the substitute arbitrator? Your cleaner, the man you've seen next door? How do you deal with arbitrators who rush in to get an award so they get more money? He hasn't answered any of that. He says it's beautiful. What he's told you is there's a problem. Well, we started this debate knowing there was a problem. You don't prove the solution by continuing to talk about the problem. That is no answer whatsoever. So what he's proposing, and what you're being asked to endorse, is a system which is already recognized as so deficient that it's already being amended twice. I mean, how can that be a beautiful system? It's so deficient that the idea now is it shouldn't apply to international arbitrations at all, which, by the way, means you will still be coming to this arbitration conference because it's an international one. The solution that is being proposed is one that will cause enormous damage. He says there are no problems. I'm told there are problems. I'm told it's hard to find arbitrators who are prepared to take it on these terms. They don't want to find that they're subjected to vitriol in court, that they lose their fees, that they're told that they can't continue with the process. So I don't see that at all. What he's really recommending to you is a procedure. We talked about surgery before. We're talking about a procedure which is supposed to be so effective, but it's one that will lead to the classic statement, the operation was successful, but sadly the patient died. That's what's going to happen with Section 29A. It's going to destroy the fundaments of arbitration if it proceeds in this way. The ability of parties to choose how they want to arbitrate, how they want to litigate and resolve their disputes. And if they want to use an arbitrator whom they know takes time, but they'd rather have that arbitrator because they're sure he or she will give them a fair hearing, a decent hearing, a hearing which looks at all the detail, why shouldn't they? Isn't that autonomy? And to say that no, the court should intervene, the parliament should intervene and say that is not possible, that is not an appropriate system. Anyway, don't worry, because it's not going to apply to us because we're international. I don't think this can be a system that you can possibly support. It only should apply to Indians, but not to anybody else. I would urge you to vote for the motion.
Final word from the debaters against the motion. Who's doing the rebuttal?
I don't want. Shall I? All right.
I just take 2 minutes.
Yes. All right, we do. Yeah, perfect. We don't have to say very much, obviously, because you haven't heard very much on behalf of the other side in response. So only 3 very short points from me, and then you'll have something much more learned from my colleague. Firstly,
do you want to say something?
We would accept that this is a blunt instrument. Yes, it is. But that is with the benefit of experience of the failure of all other instruments to date. And that doesn't mean that this is the incorrect answer. We still haven't had any solution from the other side. I gave them the invitation. It was there. He had 4 full minutes. There could have been 4 proposals. There could have been 1 suggestion. There's nothing. And so we are looking at no other alternative. There is beauty in this instrument, and the beauty is, as I explained, and everybody in the room listened apart from one of my opponents, is that it actually meets the causes It's actually tailored to what is the problem here. And the amendments, I would suggest, don't change that. Second point, the amendments don't change the nature of the cure. They may restrict them here, but actually India will still be the leading jurisdiction in the world on this issue. I have no doubt that other jurisdictions will follow, and that itself will impact upon practice here. Lastly, what seems to be motivating the other side is the sensibility of arbitrators. We heard in the first presentation on behalf of the proposing team that this is about chiding children, that we should be concerned about the psychologically adverse impact upon our arbitrators of being told what to do. We should feel very sorry for our arbitrators. We must care for them. We must tender them like children. This is ridiculous. In fact, the only problem, concrete problem that's been articulated to you with the current Section 29A is that arbitrators now feel exposed if they're appointed because they might get criticized by the court. This process is not about arbitrators. It's about parties. It's not about how the well-being of those who are paid to decide. It's about those who actually have a dispute. And it's about the process itself. And that is why, if we put that at the center, the obvious answer is Section 29A.
Just before Neeraj, you start, a request has been made by the debaters for the motion that they complete their 4 minutes, which they're entitled to. So I think Gopal's going to add 2 more minutes.
As always, Toby
note the
jumps in
telling
too
timing
quickly.
of this. Yes. No, please.
4 points. Competent arbitrators, solution 1. 2, arbitrators who are familiar with arbitration law, solution 2. 3, dedicated lawyers who take their briefs seriously, solution 3. 4, most important, have a structured case management system, and every one of this is possible. Can anybody cross his heart in this entire hall and say that they have not come across a single decent, capable, competent arbitrator or counsel who finished his job in time and delivered a stinging award? I request you, ladies and gentlemen, the solutions are all too evident. We just need to find them amongst our own selves.
Over to you, Neeraj.
I still don't see the solutions, despite the very emphatic emphasis on them. I don't see the solution at all. In fact, the only solution that has come forward is from us. And this whole business of being demeaning to the arbitrators, if an arbitrator conducts himself the way he's required to, there would never be a situation for the court to exercise the power under Section 29A6. I don't see why the arbitrators are being so apprehensive about it. These are drastic situations because arbitrators in this country left a lot to be desired while conducting arbitrations in many an arbitration. And that is why this situation has arisen. Then, I tried to break up this 12-month period, and I thought it's a perfectly reasonable period. If we were to have a 4-week statement of claim, a 4-week filing of defense, a 2-week rejoinder, a 2-week for conducting admission and denial of documents if required, 1 month for filing evidence affidavits, 1 month for conducting cross-examinations, 1 month for final arguments, and that leaves 6 months to deliver the award. And this would take care of a vast majority of cases, and wherever there is a need, as I said in my opening, the parties can go. The arbitrators at the very case management hearing right at the inception can tell them that these are complex issues. Please go and take time from the court. Now, we are looking at a situation, as we've repeatedly emphasized, where there was a serious problem. And we haven't stopped by just talking and voicing about the serious problem. We are giving a solution which has to work out. You can't just today kill it. Either you have a better solution, which I haven't heard to date, so give it a chance, let it work, and according to me, this will have some amount of very serious impact on the conduct and would possibly help save the very essence of arbitration in this country. I was told that certainty, or rather uncertainty, would come in with this amendment. To my mind, certainty would come in, and it would go a long way in saving the very essence of arbitration in this country.
Ladies and gentlemen, join me in thanking the speakers once again in the usual way. That was a fantastic, fantastic debate. Now, there's just no way I'm going to make a decision on this. So, really, it's now over to all of you in the room to give your views on whether you're for the motion or you're against the motion. There are various ways of doing this. We could sort of have a show of hands, but at this stage of the proceedings, I think let's try the clapping method. So I'm going to say for the motion, who is supportive of the debaters for the motion winning this particular debate? Okay. Okay. Thank you very much for that. And against the motion? I think it's a tough call, but it sounds like it's.
I think it does.
It does. You brought some people over from the PCA, didn't you? All right, wonderful. So I'll leave you to interpret who won. But again, it remains for me to invite you to thank the speakers once again. Thank you all. That was a wonderful, wonderful debate on a very important point. Okay, in keeping with the principles that the MCIA operates to, we're well within time. I think what remains is apparently for me to make some closing remarks, which I will do very, very shortly, and we'll go from there. I suspect there's going to be a short photo session right in front, and then I can get into the remarks themselves. Okay?